Welcome everybody to Lunch with Legal. We are so glad to have you join us here for the last Lunch with Legal of the school year. And we are here in our office, Studio HG, and I'm joined by my colleagues, Citlali Perez and Michelle Breitmeyer, and Marcy and Mia are joining us virtually as well. Let's get started here because we have some really interesting OAH cases to talk about, as well as some updates from federal court here. All right, so if this is your first Lunch with Legal, just a little bit about our firm. We have a lot of experience providing support for school districts and educational agencies, primarily in the area of special education. We've appeared in special education matters before state court, federal court, you name it. It's a very interesting area of law, so it's one that we always love talking about, especially because there are always new cases that evolve. And so OAH releases their cases on a monthly basis. And so in this month's release from April 2026, we had 12 decisions total. School districts and LEAs prevailed fully on 5. Student prevailed fully on 1 case, and 6 decisions were split. There were also 2 expedited cases, one of which we'll talk about today, and 2 consolidated cases. And a consolidated case is when there's multiple complaints that get consolidated into one hearing. So this is a very special Lunch with Legal because we are commemorating the end of the school year and celebrating all the hard work that you've put into serving school children in California. And so we have some prizes today to celebrate the end of the school year. And so I'm going to refer you to the Q&A function on Microsoft Teams, because we have our first prize here, which is a very exclusive HG Hydro Flask to keep you hydrated during the summer. And so for this first prize, if you can put in the chat the year that HG was founded, the first person to do that will win this Hydro Flask. So we're going to take a look at the Q&A or the chat function. So the first person to put in the chat, oh, I see one already. Congratulations, David Figuli. You are the winner of this very special HG Hydro Flask. And if you didn't make it in time, don't worry, we have more prizes coming up as well in the middle and the end of this presentation. But let's get started into the legal issues, because we have a big case from the Ninth Circuit that just came out. So this case is mainly about the statute of limitations under the IDEA. So we have here up on the slide the rule about the statute of limitations. And so the IDEA has a 2-year statute of limitations, 2 years from the date the parent knew or should have known of the facts underlying the complaint. And there's 2 exceptions to the 2-year rule. So first of all, there's an exception to the 2-year rule if the LEA makes a specific misrepresentation that it has resolved the basis of the complaint. Or there's also another exception if the LEA withholds information required to be provided to the parent. And so those are the 2 circumstances in which a parent can go back more than 2 years. So let's talk about how Perez evolves. And so this was a 97-page OAH decision. So we're just going to focus about the statute of limitations part here. So in the underlying OAH decisions, the decision came out in 2021, and there was an assessment in 2018. So an assessment that was 3 years old. And the assessment in question did not diagnose the student with autism, or didn't find him eligible under autism, I should say. And so later on, the family did get an autism diagnosis, and they brought a due process complaint and said because the assessment says our student did not have autism, that was either a misrepresentation or withholding of information, and therefore we should be entitled to go back more than 2 years. And so OAH, the judge at the trial level at OAH, disagreed with the parent's argument. OAH's reasoning was you knew that autism had not been assessed, therefore you had notice of the facts, therefore there's no reason to go beyond the 2 years. The student appeals this case to federal court, to the Central District in California. And so the Central District reverses OAH, and this was a decision that caught a lot of people's attention and really, I think, concerned quite a few people on the school district side of things. And so what the Central District said is that the parents had no way of knowing that the district's assessment was incorrect. The parents, quote, had earnestly adhered to the district's purported expert and lacked the specialized skills to contest the diagnosis. And so the reason why this concerned a lot of people that represent school districts is that it seemed to sort of broach the idea that if you have an assessment that is wrong, that then is a misrepresentation, and therefore anytime you have an assessment that's contested or an assessment that ends up being incorrect, you can go back more than 2 years. And so this would really be significantly expanding the scope of special education litigation, make it a lot more expensive, a lot more complicated for districts to litigate these cases if you can go back more than 2 years. And so based on this expansion of the statute of limitations, the central district ordered significant remedies for the student, but the district then appealed it again. So the district appeals it to the Ninth Circuit, and the Ninth Circuit reverses the underlying OAH decision, or the underlying central district decision rather. And the Ninth Circuit affirmed that that the OAH decision was correct and that the 2-year statute of limitations should have applied. And so what the Ninth Circuit says is that the parents knew autism was not assessed from the 2018 assessment, and the parents also had enough notice to know that the student was struggling and that there was a potential denial of FAPE. And so the Ninth Circuit looked at the student's progress, and the Ninth Circuit concluded that when the parents have knew or should have known the district's failure to assess their child and were also aware of the inadequacy of the child's education, that then provides sufficient notice and starts the clock on that 2-year period. And so there was the Perez decision, and right after Perez, there was an unpublished Ninth Circuit decision called TMJ versus Vallejo that said the same thing. And so now we have a lot more clarity from the Ninth Circuit on this statute of limitations language. And this is also now a precedent that the Ninth Circuit has set that not only gives us clarity, but it also defines very clearly the situations in which you can go back more than 2 years in a way that I think is generally considered to be more favorable for districts and limiting the number of years that a parent can go back. So this is ultimately a very important decision, very positive outcome here for school districts from the Ninth Circuit. Let's get into OAH cases. And so the first OAH case I'm going to talk about today is this case here. This is a charter school that litigated an expedited due process case against the parents. And so the charter filed to implement an interim alternative educational setting. And so this is the subject of expedited due process complaints. And so anytime there is a substantial risk of injury, that's the legal standard, a school can file for a due process complaint to have a judge order an interim alternative educational setting not to exceed 45 school days. And in this particular case, the interim alternative educational setting was general education with a one-to-one aid, a behavior intervention plan, and BCBA supervision. And this was for a student who previously had been in, I believe, a resource support type program. And so this case is notable. Typically, districts prevail in these cases. And this case is notable because the school at issue did not prevail. And so we want to look at why that happened, because it gives some interesting reasoning here. So specifically, what the ALJ found that there was just a generalized risk of harm from the school's concern, and that this was not enough to trigger the substantial risk of injury standard. The second part of the ALJ's decision that is also quite interesting is the treatment of the proposed interim alternative educational setting. And so I remember a few years ago, there was a case that similarly came out that said the interim setting proposed by the school district was not appropriate. And so here we have one more example of the standard used by judges when they're looking at the appropriateness of these interim settings. And so here, the student essentially would have remained in the same setting, the ALJ found, because the interim alternative setting was still general education, although with supports like a BIP and an aid and a BCBA supervision, all things that the school had offered through the IP process, but that the parent had not consented to. And so what the ALJ said is that for interim alternative educational settings, the law requires that the interim setting be actually a removal from where the student was before. And so if the student is staying in the same school, in the same gen ed placement, albeit with different types of supports, that's not a removal. And so here, you didn't have the first standard met. There was no substantial risk of injury because the student had some behaviors, but staff also testified, and there was some evidence that the judge looked to show that these behaviors were getting better. And although these behaviors were disruptive, there wasn't a direct risk of harm. And the second point too, again, is that the interim alternative educational setting has to be a different setting from the one that the student is already in. And so in this case, the student prevailed, and the charter school was not able to implement its interim offer. And let's go on to our next case here with Temecula.
Hi, everybody. My name is Michelle Breitmeyer, and today I'm going to talk to you about a case that comes from Temecula Valley Unified School District. This case is really about what happens when a district attempts to exit a student and the parent does not provide consent. At the time of the hearing, the student in this case was a 16-year-old. He was in the 11th grade, and he had qualified previously for special education services under the category of other health impairment. During the 2023-2024 school year, he transitioned from his middle school to the high school, and they conducted some triennial assessments in the areas of psychoeducation and speech and language. After reviewing the data, the team decided that the student no longer qualified for special education, and they proposed exiting the student from special education. Well, the parent disagreed. And remember, the student is in 11th grade at the time of the hearing. So the parent had disagreed for the entire 3 years from the time that he transitioned into high school until the hearing. So 3 years of disagreement. The ALJ did consider the assessments and found them to be legally compliant and accurate and comprehensive. But the issue that was brought is, did the district fail to find the student eligible under OHI? So based off of the assessments, the district did not make a new offer of FAPE. They did propose transitioning the student to a 504 plan. Parents did not consent. The ruling actually described the actions of the district kind of intensely. They called it a war of attrition over 3 school years to force the parent into consent. So that kind of took me by surprise that the ALJ noted that the district was trying to force the parent into consenting. The district stopped monitoring the goals. They stopped with the services. They did not consider if any other assessments were needed. They did not engage the parents in any other way, and they repeatedly asked them for consent to terminate the student's eligibility. The district argued that they did not need to file for due process because they believed that the student was not eligible for special education and therefore did not require any of the procedural protections. But the ruling noted that the district implemented a stale IEP dating back to the student's middle school years with the same goals, services, and accommodations for 3 years. The ALJ also said that the district believed so strongly in its position for 3 years, however, they failed to seek authority from the ALJ from OAH to exit the student. And the greatest harm inflicted in the district's failure to properly exit the student was that he spent the vast majority of his high school time in an IEP that was completely inappropriate. So the student did prevail on this one. He prevailed, and it was determined that he was denied a FAPE by not being found eligible under OHI. And surprisingly, this one kind of took me by surprise. They were only ordered to fund 20 hours of compensatory education based off those 3 years that they denied the student FAPE. All right, so this next one comes to us from Simi Valley. And this one has a lot of dates, so you'll have to follow along. I'll try and keep you up to date with all the dates that this one has. But overall, this one's about how does a district know when they have a basis of knowledge that a student has a disability prior to being found eligible for special education. So this student was 13 years old and in 7th grade. He had an active 504 plan based on a diagnosis of ADHD, which was impacting his social skills, his behavioral skills, his academic skills. But the student was suspended, ultimately for more than 10 days. He was placed on an expulsion order for purchasing, using, and selling a THC pen on campus on January 9th. So that's one important date. January 9th is when the incident happened. Back in November, the parent had requested evaluation. So that was 2 months before the suspension. Parent had requested a special education evaluation. So the parent contends that the district had a basis of knowledge because 2 months ago they had requested a special education assessment. And the district actually granted the special education assessment on December 1st. So now they have an assessment plan, and the parents say that they were entitled to a manifestation determination because the district had a basis of knowledge that the student may have a disability. But 3 days after the suspension incident, so January 12th, grandfather, who had educational rights along with mother, will revoked consent to the assessment plan. And they do go into reasons why he revoked consent, but they're not necessarily relevant to this. But he basically wanted to consult with outside therapy providers for the student to see if the assessments were appropriate for the student. However, the district told grandfather, we have to follow through with these assessments per the plan unless you revoke consent. Well, grandfather decided to revoke consent 3 days after the incident occurred, 3 days after the suspension. So the district held that they did not have a basis of knowledge because parent withheld consent for the assessment plan, and therefore they could not form a basis of knowledge that the student had a disability that required special education. However, parent argued that they did have a basis of knowledge because parent already requested the special education assessment. Ultimately, the ALJ ruled in front of the parent because, and this is a quote from them, basis of knowledge is determined by looking at what the district knew before the January behavior occurred. So because the behavior occurred 3 days after the assessment, 3 days after the assessment plan, the ALJ held that the district did have a basis of knowledge because the incident occurred prior to parent revoking their consent. The ALJ also held that the district only gave grandfather one option. His option was to withdraw. Instead of sending a new assessment plan or working with the parent, they only gave grandfather one option to withdraw. So ultimately, the ALJ held in favor of the parent on this one and determined that the school did have a basis of knowledge.
Okay, it's time for our second prize here. Our second prize here is a $25 gift card for DoorDash. Since you're having lunch with Legal today, maybe in the future you can have lunch on us as well. And we wanted to give this prize to the first person to register for today's event and attend. And so congratulations to Jeanette Cervantes from West San Gabriel Valley SELPA. You are the winner of our DoorDash gift certificate. We'll get in touch with you and send that your way, Jeanette. Now, our next case here is Parent versus Irvine Unified.
Thank you, Tillman. Hi, everyone. My name is Citlali. We're going to be talking about Parent versus Irvine. Actually, these next two cases that I'll be talking about have to do with private placement. But the first case is a 14-year-old ninth grader eligible for SPED under autism and speech and language disorder. But the main problems that the child was facing was he had a lot of behavioral issues. So the student attended the school, an elementary school within the district, and there was a lot of conflict there. So the parents decided to unilaterally move her to a virtual private placement. So that happens in 2021. In 2023, the parents go back to the district and they say, hey, we'd like to consider transitioning back into the district. Could you please make us an IEP? So the district works together with the parents to create an IEP where basically the offer of placement is a 7th grade general education class for 61% of the time. And the other 39% of the time, the student will be in a practical class, which is a small, highly structured class with low student to teacher ratio that offered a modified curriculum at a slower pace and usually served 6 to 9 students each. And they also offered a lot of services and a behavioral trained one-to-one aid, as well as ESY and an updated BIP. But the parents rejected the offer. They really wanted the student to remain in the private placement, so they didn't go back to the district. So when it came to the parents decided to file for due process, and they requested reimbursement for their private placement, as well as services they obtained when they took the child to South Africa for 2 months and received like tutoring services. So they wanted reimbursement for the private placement as well as those tutors. Can I get the next slide, please? Thank you. And the ALJ, there was a couple of issues here, but I wanted to focus first on what the ALJ stated about the findings of the parents' expert witness. They really hinged their wagon to a psychologist, but the psychologist the judge quoted, was more of a legal advocate. They were making inappropriate legal opinions and was not bringing in subjective analysis, as she made also great observation as to why the IEP offers were not FAPE, but the ALJ stated that that's actually not her job. Her job was just to provide what the data stated, and that was his job to give the opinion. and the expert formed her views of the appropriateness of district's IEP offers by applying standards that were much more demanding than those the IDEA requires, as the IDEA only requires a basic floor of opportunity for meaningful progress. As the quote states, a lack of progress does not necessarily show that an IEP was flawed. The IDEA requires that a student be given the opportunity to make meaningful progress, but it does not guarantee the result. He'll stated that her opinions and the factual premises on which they were based on are at least in part barred from consideration here by the snapshot rule. What I mean by that is that she had observed the student in the fall of 2025, and so she was saying that, well, the district, this 2023 plan that they made and this 2024 plan that they made for the student, it was not appropriate because look at the data I collected in fall 2025. And the judge says, well, the snapshot rule bars that. And so that means that an IEP is evaluated in the light of information available to the team at the time it was developed. It is not judged in hindsight. The key is where the program at the time it was drafted was objectively reasonable. And the judge here stated it was. So the parents were denied relief. So this next case is Parent versus Mount Diablo. We have a 15-year-old high school student who actually was SPED eligible in 3 categories: autism, speech language disorder, as well as other health impairment. This student had a varied educational placements. He was in public schools within the district. We had him also in private placement because of the parents, but then also at some point the IEP team decided that a private placement was good for him, but then he was expelled for bullying. Then they had him in a short-term residential treatment center and then a long-term residential treatment center. There was 4 times where he was placed on involuntary psychiatric hold after self-harming. And the district, though, when they offer their FAPE offer, they in the 2025-2026 school year, they stated that a special day class on a comprehensive public high school campus is the best setting for him. But the parents said, no, he needed a more restrictive setting in a residential treatment center, which is where he was at currently when the hearing was taking place. The ALJ agreed with, the parents filed for due process and they requested reimbursement from the district for the residential treatment center that he was at. And go to the next slide, please. Thank you. So there was a lot of procedural claims. They stated that the goals weren't, parents said the goals weren't accurate enough, that the services provided weren't correct. And then they made the big claim, which is that the student was not in the least restrictive setting for him. But in this case, it was very interesting. Rachel Holland factors were not applied because both settings were actually 100% outside the general education setting. So the judge was actually looking at which was better for him: the residential treatment center, or the special day class where he was 100% outside of general ed. And the judge agreed with the parents. He had a lot of behavioral issues that a special day class was not going to be able to help him out with in achieving his education. And so but when the parents wanted the special day class, the parents wanted a 24/7 RTC, line of sight observations, intense immersive therapeutic services, as well as complete removal from general education due to the physical violence, severe vulnerability, and active suicidal threats that he made towards himself. And so the district was actually granted, the parents were granted a tuition reimbursement of over $88,000. I forgot the K there, but not $88, over $88,000, as well as travel reimbursement for his placement in that RTC. However, the judge denied they wanted that to be his permanent placement, but the judge stated that no, an IEP meeting had to be held in order to consider whether that RTC placement should be his permanent placement. Thank you.
Okay, we are down to our last 2 cases that we're going to talk with you about today. As Tillman mentioned earlier, 2 of the cases from the decisions from April were something that we call consolidated cases. And that's when the district files for due process and the parent files for due process. There's 2 different complaints and they consolidate them together. As you can see here, this is the case of San Benito. And the big picture on this case is it has to do with IEEs, these independent educational evaluations, right? So lots of us get requests from parents for the district to fund an IEE. And in these cases, there's only 2 options. You either have to fund the IEE or you have to file for due process to prove that your own assessment was appropriate. Well, has anyone out there ever had an IEE request from a parent and you say, okay, yeah, we will grant the IEE. And then for whatever reason, parent is either not responsive or drags their feet or insists on a certain assessor, and the assessor that they want is really far away or really expensive and exceeds the caps that are set forth in your policies, right? That's what this case has to do with. This particular case, the parent requested an IEE in October of 2025. The district said, yes, we'll agree to fund the IEE just shortly after that. Well, then the parent replied and said, okay, here's the assessor that I want, but the parent didn't give the district the contact information. Why? I don't know. And the district said, we'd love to fund this IEE, but we need the contact information so that we can actually reach out to this person to get this IEE going. And there were all these emails going back and forth, parents complaining, parent is saying, I don't have to give you that information. There's nothing that requires me to give you the contact information, yada, yada, yada. And then the district had to do some research and track down that this person that the parent wanted was like in some city that was like super far away. So the district was like, we can't do this. We can't fund an IE assessor for someone that lives in this other city far away because it exceeds most of your IE policies. There's a geographical limit. So always look at your policies. Well, the parent filed for due process and said, district, you are taking too long. You're supposed to respond to my IEE request. There's a specific timeline. And if, as you know, if you get these requests, the timeline is very vague. It's you have to respond without unnecessary delay. So with our own assessments, we have 60 days, right? But when a parent wants an assessment, we have to do an assessment plan within 15 days. But when there's a request for an IEE, there's no 15-day timeline, but we have to respond without unnecessary delay. Well, here, the delay was kind of necessary, right? Because the district's trying to get information about who the contact provider is. The district finally said, hey, can you propose some different assessors? Because this one's so far away. Well, the parent said, hey, there's no legal authority that requires me to verify their identity, and I don't want to pick new assessors. I want my original assessor. This case goes to hearing, and even at the hearing, when parent was testifying, parent still could not provide the contact information during her own testimony. So the district was able to prevail in this case. The judge said actually that the district devoted, quote, much time and effort into doing everything it possibly could to set up these IEEs, but for whatever reason, parent wasn't very forthcoming with the information needed to go through with the IE process. So the district prevailed in this case and was able to show that it did respond to the request for an IE without unnecessary delay, which is what the law requires. So the takeaways in this case, whenever you have an IE request, always make sure that you pick one of the two options that are set forth in our IDEA. You either have to fund the IEE and say, yes, I'll do this. Here are SELPA policies, and the parent has to follow those policies, or you have to file for due process to prove that your own assessments are appropriate. It's also very important that you give the parent a copy of the SELPA IEE policies, right? So that way the parent knows, okay, here's the policies, here's the criteria that I need to follow with. And that's why the district in this case had all of that documentation. So they were able to show the judge at hearing all of the emails, all of the evidence to prove that they did the right thing. Let's go ahead and move on to the next case, our last case. I see that we have 1 more minute and we're going to wrap this up. I know we have another prize we're going to give away. This again is a consolidated case involving Capistrano Unified. Gosh, lots of litigation out there involving Capistrano Unified. I feel like almost every month when we talk about these cases, poor Capistrano Unified, I think has been in every month of our cases. But this was a hearing that lasted about 5 days with ALJ Jennifer Kelly. And the big picture, this case is about LRE and what happens when the school district proposes an NPS. In this case, the district said an NPS was FAPE. Parent said no, parent wanted the district's special day class. But this student has significant needs and significant behavior issues. This decision, like I mentioned, it was a 5-day long hearing. The judge wrote a decision that was 106 pages long, summarizing all of the testimony. The parent had an expert that testified, and their expert said, district, you should not offer an NPS. The student should be in a special day class. Well, all of the district staff testified too, and guess who the judge agreed with? The judge agreed with the school district. The school district was able to prove that because of the student's extensive needs and significant behavior issues, the student did require a non-public school, and that was the LRE, not a special day class. And I know those cases are always hard when we have a disagreement over a placement, but it's important that we're able to show the takeaway here is that we want to show we've tried all these things. It's not working here in this setting. We need to move to a more restrictive setting. And the district, in this case, Capistrano, was able to show that they did all of the legal things necessary to offer the LRE of a non-public school placement. So take a look at that case if you have that kind of placement dispute, and we are done. I think we're going to move on to our prize giveaway, Tillman.
We have our final prize right here, my favorite prize actually. But right before we get to our final prize giveaway, I just wanted to let you all know just a couple things that are coming up. We're going to take a hiatus over the summer for Lunch with Legal, so enjoy your summer breaks, but we will be back on August 14th at our usual time. The QR code is there, so please sign up. It'll be a great Lunch with Legal because we'll have lots of cases to review that came out over the summer and probably a lot of interesting legal updates. One more thing right here. In September, we're also going to have our Cultivating Legal Excellence event. And if you attended today's training, you're going to get 10% off of this event. And we're going to try something new for this event. It's going to be both in person and virtual at the same time. And we're going to have interactive elements for the virtual and in-person participants. And so the in-person part of this is going to be at the old sugar mill in Clarksburg, right close to Sacramento. It's a great venue. There's a lot of event space there. It's really beautiful. There's a lot of wineries there as well. So we'll have the training from 10 to 2 and then a reception after that. If you want to join us virtually as well, there's going to be that option too. And the QR code is right there for you to sign up for that event. And so now let's get to our final prize right here. Our final prize is this very special HG. An HG wine glass right here, which is, of course, a critical ingredient to enjoying your summer break. And we are going to give this to a random participant on today's call, but we appreciate all of you signing up today. So can somebody give me a number between 1 and 10?
5. So right in the middle.
5. Okay, let's split the difference. So Kathleen Lopez, congratulations to Kathleen Lopez. You are the winner of this HG wine glass. We'll get in touch with you and figure out how to send that to you as well. Thank you all so much for joining us. Thank you all for joining us so much during this school year. We really appreciate the opportunity to talk with you all during Lunch with Legals. Hope to see you back in August and then September for our continuing legal, for our in-person event. Thank you all so much.
Thank you. Have a nice summer, everybody. Enjoy summer. We'll see you later. Bye-bye.